I'm calling to order a public hearing of the Committee of the Whole of the Council of the District of Columbia, together with the Committee on Judiciary and Public Safety. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole, and with me is Councilmember Brooke Pinto, who is Chair of the Committee on the Judiciary and Public Safety. The subject of this, I should back up and say today is Tuesday, January 16th, 2024. The time is 11:05 in the morning. And this hearing is being held, largely virtually. But I'm sitting in council chambers, room 500 of the John A. Wilson building. It's a little lonely in here. We just got joined by a council member. But most of the witnesses, there, I believe 5, will be virtual, and the government witnesses will be virtual as well. The subject of this hearing is Bill 25-309, entitled Special Education for Young Adults in the Custody of the Department of Corrections, Amendment Act of 2023. This legislation was introduced at the request of the mayor on June 1st of this year. The stated purpose of the bill is to designate the Department of Corrections as the district agency responsible for the provision of a free appropriate education under the Individuals with Disabilities Education Act. Services would be provided to individuals with disabilities who are in its custody, that is the Department of Corrections custody, and detained in its secure facilities through the end of the individual's eligibility. Council passed temporary legislation to the same effect on June 20th of last year, that is June 20th, 2023, which is set to expire on May 17th. The second bill that is the subject of today's hearing is Bill 25-461, entitled Leading Education Access for Reentry and Necessary Success, Amendment Act of 2023. This legislation was introduced by Councilmember Brooke Pinto and co-introduced by 7 other council members on September 18th of 2023. And the stated purpose of this bill, well, it's similar to Bill 25-309 in that it would designate the Department of Corrections as the district agency responsible for providing a free appropriate education to eligible individuals in their care. However, this second bill, Bill 25-451, additionally specifies that the Department of Corrections must provide evaluations for special education services, and it specifies qualifications for entities seeking to contract with the Department of Corrections to provide special education services. The bill also includes a provision with regard to the grievance process at the Department of Corrections. And I'm going to leave that to Councilmember Pinto, or Chair Pinto, since she's co-chairing this hearing, to explain further. The record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Tuesday, January 30th, 2024. Anyone who wishes to submit comments or written statements after this hearing is invited to do so, but must do so if they want it included in the record by 5 p.m. on Tuesday, January 30th. With that, let me turn to my colleague and co-chair, Councilmember Brooke Pinto, and then I will call in the 5 public witnesses. Councilmember or Chair Pinto.
Great, thank you so much, Chairman Mendelson, and thank you to you and your team for all of your work in co-chairing this hearing today. When a young person becomes justice involved, it can disrupt many facets of their lives, and one of the first things to be interrupted is the young person's classroom instruction and their learning environments. When a person with learning disabilities becomes justice involved, the process can be even more disrupting and produce far more serious and lasting consequences. It is very important for us to continue to move forward and acknowledge that every person, regardless of their circumstances, deserves access to a quality education in our city. And that's why I introduced the Leading Education Access for Reentry and Necessary Services, or the LEARNS Amendment Act of 2023. Along with council members Robert White, Charles Allen, Vince Gray, Matt Fruman, Janice Lewis George, Anita Bonds, and Treyon White. This legislation seeks to bridge the educational gaps for youth that we've seen in our correctional facilities in the past, by ensuring that everyone receives the same educational opportunities as their peers outside of the system. The bill requires DOC to be the oversight body who will be responsible for choosing a qualified education contractor to provide free and appropriate public education, otherwise referred to as FAPE, to students who are eligible for one. DOC, as the agency responsible for maintaining this contract, will work with the Office of State Superintendent and the Deputy Mayor for Education to ensure that there is no lapse in quality educational services provided to students in their custody, regardless of the contract's end date. The LEARNS Act also requires that DOC provide evaluations for students who were not previously evaluated for special education services before their arrival at the facility. And this is a really important component of this bill. This does not extend to students in DOC custody. This legislation will help ensure that every student in the district has access to FAPE, regardless of their living situation and regardless if they had that evaluation done before becoming justice involved. Lastly, the legislation seeks to strengthen the grievance process at DOC by requiring the agency to establish an online, publicly accessible portal where residents, their families, and the public can find contact information for agency leadership and a list of rights for residents who are in DOC custody. This new portal would allow residents, their legal representative, or a designee to submit grievances, complaints, and requests directly into the tracking system, allowing for the individual or individuals' families to track the status of said request in real time via updates from the agency. Education is a powerful tool for rehabilitation. By focusing on educational services within correctional facilities, we can help prepare our youth to successfully reintegrate into their communities, pursue employment opportunities, and contribute positively to society. This is especially crucial for youth in correctional facilities who may face unique challenges. Customized individual education plans can address learning disabilities, mental health issues, or other factors that might hinder a student's educational progress. This proposed bill is not only about education, it's also about investing in the future of our young people and fostering a district that believes in transparency and the transformative power of education for all. Thank you again, Chairman, and I look forward to hearing from our public and government witnesses today.
Thank you, Co-Chair Pinto. We have been joined by Councilmember Zachary Parker. If he has an opening statement.
Thank you, Chairman Mendelson and Councilmember Pinto, for hosting today's hearing on two very important bills, B25-309 and B25-461. For B25-309, this legislation, as has been mentioned, would designate the Department of Corrections as its own independent local education agency. Up until this point, Maya Angelou Public Charter School has been providing educational services to students there at the jail in need, and by all accounts has been doing a great job. By designating the Department of Corrections as its own LEA, there will be some needed changes and requirements, both in terms of reporting, but also services rendered. And so today I'm interested in hearing how the Department of Corrections plans to ramp up its oversight and implementation to meet these requirements. For B25-461, this legislation, as has been mentioned, would mandate the Department of Corrections evaluate students for special education services who were not assessed prior to entering DOC custody. This addresses a critical gap in the current system, ensuring that all students, regardless of their evaluation status before incarceration, have the opportunity to be assessed for special education services and mental health issues. I look forward to digging into both of these bills and believe that they will have a great impact if implemented. So thank you, Mr. Chairman.
Thank you, Councilmember Parker. So let me call the first five witnesses: Ashley Ruff, Sarah Camo, who is Director of Programs and co-founder at the School Justice Project; Salim Adolfo, who is an ANC Commissioner and possibly Chair, I'm not positive, of ANC 8C; Teo Bell, who is Managing Attorney at the School Justice Project; and Reverend Anthony Motley. They could each be let in. The moment I see exactly one. There's nobody else in the waiting room. All right, well, let us proceed with the one witness that we have. I will remind the others, even though they're not here or listening, is that the record will be open for 2 weeks. So we have Sarah, is it pronounced Como?
Hi, good morning. It's Sarah Como.
Como. Why don't you proceed? And guess what? Today's your lucky day. Not only did it snow, not only are we having this hearing, but since you're the only witness, we'll have a clock, but I'm not going to hold you to it.
Oh,
Unless
that is my lucky day.
unless Councilmember Pinto objects. So go for it.
Good morning. I apologize in advance for how I sound. My name is Sarah Como. I'm the Director of Programs and co-founder of School Justice Project and a Ward 1 resident. I'm testifying in support of both bills here today. There must be an entity responsible for ensuring that young people within DOC custody, including those at St. Elizabeth's, can access a quality high school diploma program and receive their federally guaranteed special education rights. Additionally, just because a young person is within a secure facility is not a sufficient reason to strip them of the same opportunities to receive supports and to learn as their peers in the community. I caution that DOC must not and cannot be the permanent solution to our quest to identify an education agency responsible for students with disabilities in DOC facilities, but there must be a responsible governmental body today. I look forward to working with this council as we find the appropriate and permanent solution. The Individuals with Disabilities Education Act, or IDEA, mandates that every eligible student with special education needs shall have available to them a path to a high school diploma through the school year in which they turn 22. This right to be enrolled in school and work toward a diploma is not modified when an individual enters custody. Under the IDEA, there must be an entity responsible for ensuring that all eligible students can access a free, appropriate public education, or, in other words, can work toward their high school diploma, earn credits, and receive all the services and supports they are entitled to under federal law. The entity deemed the Local Education Agency, or LEA, is responsible for making sure that this guarantee is available to all students within its jurisdiction. Recently, DOC has been named the public agency responsible for ensuring that students can access an education and is tasked with contracting with an education provider. Under this designation, the public agency responsible for providing a FAPE, DOC has the identical legal responsibilities as a LEA would. This includes being able to be sued if they do not comply with their obligations. We do not support a corrections agency serving as a LEA or the public agency responsible for education. A corrections agency does not have the expertise or qualifications to do this. Education agencies should provide education, not jails. But if such an agency must temporarily bear this responsibility, it should be held to the highest standards. We support the LEARNS Act in that it codifies the requirements of a school that DOC must contract with to fulfill its LEA obligations. We believe that DOC's legal responsibilities should not be limited to individuals within DC jail and CTF, but should extend to all students within DOC custody, including those at St. Elizabeth's. Students in DOC custody at St. Elizabeth's have the same rights to education as their peers in DOC facilities, yet receive nothing. When young people are educated, communities are safer. If a young person in the community between age 18 and 22 has a disability that impairs their ability to learn, they have the right to request an evaluation. That right is extinguished if that same individual seeks an evaluation while incarcerated. This produces an absurd result. Trauma and mental health issues are only exacerbated by incarceration. Incarceration results in high school dropout. Dropout leads to unemployment, which is an indicator of future court contact. Special education not only gives young people access to a high school diploma, but also provides tailored and individualized mental health supports to students. The provisions within the LEARNS Act that allow for young people to be evaluated provide a common sense public health solution to cycles of violence and will make us safer. This provision just provides students in DOC the same opportunity they would have if they were in the community. We encourage these committees to work together toward a solution that benefits all young people. Find an education agency that is responsible for education within DOC and St. Elizabeth's. Only when all our students can access education can we all truly achieve a safer and more equitable district. Thank you so much for your time and for introducing these two bills. I'm here for questions.
Thank you, Ms. Como. I don't have a copy of your statement. It'd be helpful if you provide that. And while
Absolutely.
you were speaking, a couple other of the witnesses joined us. Theo Bell.
Good morning. My name is Theo Bell. Hello. And I'm the managing attorney at School Justice Project along with my colleague Sarah Como. I'm also a Ward 4 president. SJP is a DC-based legal services and advocacy organization, as my colleague described. I'd also like to note for today's council members that SJP is also a co-counsel on the Charles H. versus District of Columbia class action lawsuit. I just want to provide an overview of the litigation today and some of the examples to illuminate why we support this bill today regards to the Special Education for Young Adults in the Custody of the Department of Corrections Amendment Act. I've included more detail in my written submitted testimony. Admittedly, SJP initially had doubts about the emergency legislation this council approved, designating DOC as the public entity responsible for providing public education. As my colleague described, we do not see that as a role best played by a correctional institution. However, over time, we have come to understand that because of the unique interplay between the DOC and the high school at the jail in this circumstance and for accountability purposes, it is best for DOC to play the role of the quasi-LEA. As the council is aware, in March 2020, DCPS announced that all of its schools would begin distance learning. For most students, DCPS resumed classes and related services via video instruction. However, for students detained in the DC jail, DCPS only provided students with printed work packets with no teachers, and these were special education students. In the spring of 2021, 3 SJP clients who are incarcerated at the jail brought a class action lawsuit against DC for denying them access to their federally protected special education rights under the IDEA. Under that statute, incarcerated students with disabilities are entitled to the same special education protections as disabled students in the community. The Department of Justice also weighed in by filing a statement of interest on behalf of the United States, making it clear that the obligations of DCPS and OSSI were the same even during the pandemic. A federal judge agreed with the students and ordered a preliminary injunction and mandated the district provide education at the jail. The next school year, DCPS was replaced by Maya Public Charter School. And despite Maya Angelou's efforts, it soon became increasingly obvious that the problems that had plagued the high school at the jail were twofold. One, DCPS and OSSI had failed to make education available to eligible students and to supervise that process. But equally important, the DOC had failed to make the educational program that was available accessible to those students with disabilities. After a contempt finding and a year of confidential mediation proceedings last September, the parties executed a settlement agreement. Of note, the settlement provides for injunctive relief in the form of policies and practices, some of which are underway. Secondly, the settlement created a third-party auditor role to ensure the numerous provisions of the 69-page settlement are complied with. And finally, the settlement offers compensatory education relief in the form of an education award that the class members can use to further their goals. For some members, a post-secondary education may be the goal, and the award can assist with paying for tuition, room and board, fees, and a laptop. For others, the award may be used for something more innovative, like a vocational program where they learn barbering skills and can earn a certificate to make them employable. While there are parameters on the use of the awards, including applicable time periods, class members can use the awards flexibly in the hope that in doing so, they will become contributing members of our community during their reentry. Again, for the reasons my colleague noted and those outlined in my written testimony, which is more extensive, today we do support this bill, but I of course look forward to continuing to work with the district to find a more permanent solution that would satisfy the needs required under law. Thank you.
Thank you, Ms. Bell. And I do have a copy of your statement. Reverend Anthony Motley.
Yes, good morning.
Good morning.
Can you hear? Yeah, good morning. How you doing?
Yes. Okay, haven't seen you
Okay,
in a while.
I know, and we haven't had a chance to really, really talk real serious. But look, thank you for this opportunity to be with you this morning and the other council members. I want to support this legislation. However, I think that it's important that we bring to the table those individuals who helped to deal with the reform back in the day. Sometimes history does give us lessons learned, and we would like to see more of those of us who participated in the reforms of the DC DYRS and special education programs back in the day to be part of the solution. Now, what I also recommend is that we take these initiatives that we have now and make sure that we speak to the community. There's a way to do that. We have libraries, so we need more library conversations with our community, inviting the community to meet at the libraries. We also have an opportunity to speak with our barbershops and our beauty salons and speak to the parents and the children who frequent those establishments as well. These are things that we initiated last year and during the summertime, and we had a barbershop conversations, and we helped to get haircuts and hairstyles for our young people, and talk to the barbers and the hairstylists about when they bring them in to have conversations with the people about the issues that we're dealing with. So I would just say, let's continue to do what we have to do, but bring in those of us who've made a way and given some lessons learned so that we can get the best of our city. Thank you for this time, and I apologize for not having a written testimony, but I've been real busy this past week. So thank you so much.
Thank you, Reverend Motley. And the record's open for 2 weeks. So if you want to submit a written statement, you have 2 weeks to do so.
Okay, thank you. I will. Thank you, Brother Chairman.
Thank you. Let me, there are no other witnesses at this time. So Co-Chair Pinto, why don't you start off with questions if you have any?
Sure. Thank you all so much for joining us and sharing your perspective and the work that you do in this space. I want to ask you, Ms. Como or Ms. Bell, about any particular clients that you've worked with that you can elaborate on, of course, maintaining their confidentiality, but about the current gaps in services, especially about determining if someone is in need of special education, to inform why this is so important.
I have a couple examples, and I'll turn to my colleague, Ms. Bell, who I think also has some good examples. We have been receiving a number of referrals on behalf of defense attorneys, on behalf of young people that are inside DOC, and they've said, my client really wants to go to high school and can't enroll in the school. After meeting with the client, it becomes very clear that this client is someone who would be entitled to special education if they were in the community. But because they're in DOC, they can't get evaluated. So what happens is this client just sits inside DOC without any access to any services, without any special education or educational programming. If client goes to the Federal Bureau of Prisons, what will happen to this young person, because they don't have a high school credential and because they likely are not going to receive any of the supports they need through a GED program, they will not be able to access a lot of the post-secondary and vocational programming inside BOP facilities. When they come home, they'll come home to a service desert. They may be too old to enroll in any high school education program. They'll not be receiving any mental health supports or services to assist them in securing employment and to get them on their feet and to get them stable. So we're seeing this real cycle of stripping young people of rights when we could just allow them the opportunity to be evaluated inside the facility and then go to school. And I think at this point, I'll let Ms. Bell provide any other examples.
Thank you.
Thank you, Sarah. Yeah, we have seen issues such as those repeatedly. In addition, I'd just like to point out that though we have seen a tremendous increase in the services provided at the DOC since truly the filing of this lawsuit and certainly the settlement of it, we are still experiencing issues with students getting access to the services and the education that they need. There are things like receiving an educational tablet, which are not provided on a daily basis before school starts. There are issues such as students who have truly significant mental health needs needing to really be treated uniquely as per their IEPs and the understanding of the young person's needs from the facility staff who are not being brought to the classroom spaces because we haven't really, the DOC really hasn't figured out yet a way to properly educate them. So there are still some gaps in the provision of instruction and services at the DC jail, which I know Ms. Burnett is testifying later today. And, you know, I think that things are truly coming along, but there are still some gaps that we do see as a result of, you know, frankly, some of the concerns on the DOC side, not necessarily the provider, the educational school provider side, Maya Angelou, that we would like to see rectified. And we are working very closely with DOC staff and the staff at Maya Angelou to help resolve these issues as we're made aware of them. And I will say that they, for their part, they are certainly aware of and are trying to move forward with those problems, but unfortunately we are still seeing them.
Okay, thank you so much for that update. That's helpful. And then you both kind of touched on initial concerns you had with DOC being responsible for this, but now thinking it may be okay on a temporary basis. Can you elaborate a little bit on what your thinking is there?
Yeah, go ahead. Okay. Sure. So from a policy perspective, education agencies should be responsible for education. They are the agencies that are tasked with like knowing how to educate young people. A corrections agency does not know how to do that. They don't have the staff, they don't have the experience, they don't have the qualifications. In this instance, because we are in a, you know, Ms. Bell touched on this, we are in a very unique situation with a class action settlement agreement in effect, with DOC having a contract with an education provider. We want to ensure that there's education continuity and that someone is responsible for education. And so in this instance, because DOC has been named the public entity responsible for providing a FAPE, we don't want to disrupt that today. We want to work with the city and with the government to come up with an appropriate solution in the future, and recognizing that today we do need an entity that is responsible for this and is on the hook legally.
And if I may add to that, council member, the IDEA does outline a situation in which an LEA is unable or unwilling to provide education to students who are entitled to special education needs. In that situation, typically the SEA or the state education agency here, that would be OSSI, is then responsible to come in and provide the education or make available the education through, you know, some other means, another provider, for instance. That would be the typical solution. As you are well aware, the council is well aware, there was a report done several, well, time has kind of taken an interesting turn in my mind, but I think it was about a year ago at this point, where the district was trying to decide who would be this, you know, either quasi-LEA, if it was, you know, the DOC, or if it would be an actual LEA such as Maya or DCPS. And ultimately it decided on the DOC, which is how we came to be in this position today. As my colleague stated, right now, and particularly because of the challenges of the actual accessibility that the students at the jail are having, and the challenges that they're having in sometimes getting their education that really are more DOC issues that they could resolve. In this case, in this limited case, and for this limited time period, it seems most appropriate that DOC would be the education entity responsible for providing it.
Okay, thank you very much for that clarification. And thank you, Reverend Motley, for your comments as well, and I particularly appreciate your points about libraries and how exposure to reading opportunities is so important for our young people, and everyone in the district. So thank you for being here as
Yeah,
well.
yeah, Councilmember Pinto. One of the things we find is that when we with conversations, we find answers. We are able to find, like, we have parents and guardians who, if they're at the library sometimes, or at the barbershop or the music, they talk, and then they say, you know what, I didn't know about that, or I didn't know how to get in contact with this group. So it's kind of trying to get ahead of things before we get to, the incarceration piece. So that's why I was trying to do a preventive piece.
Absolutely.
You know,
So
yeah.
important. So important. And I
Okay.
think especially as we're in this kind of post-COVID world when so many notices and things are virtual, and making sure that we're still reminding folks in the community in hard copy of opportunities and services that are available to them is important.
Yes.
Moving forward.
Okay. Thank you so much for everything. Okay.
Thank you. Thank you all for being here. Appreciate it. Mr.
Thank you.
Back to you.
Thank you, Co-Chair Pinto. I'm going to turn to Councilmember Parker, and then I'll have a few questions.
Thank you all for your testimony. I want to pick up on the DC jail serving as an LEA and make sure I'm tracking. So it seems like you all are satisfied with the Department of Corrections serving as an LEA in the short term. How long would you recommend we keep this structure in place? And then related, I think the testimony, Ms. Bill, you offered is that you're suggesting that OSSI provide the educational services there at the DC jail in the long run. And just correct me if that's not accurate. So how long should this, as you put it, temporary structure be in place? And is it accurate, if I interpreted your testimony correctly, Ms. Bill, that you think OSSI should be the provider in the long run?
Thank you, Councilmember Parker. I don't have an exact answer for you in terms of how long DOC should act as the LEA for purposes of this hearing. I would say that at a minimum, that period should last through at least the termination of the settlement agreement in the Charles H. case, which is August 2025. I think, this will be a critical few years to determine how this new system works and to get some new policies and practices underway, and I'll also allow them time to be implemented with fidelity and to work out any kinks that may occur. So I would say at the minimum, at least until August 2025, when we can begin thinking about other alternatives. My point on the SEA taking over education provision is not necessarily the OSSI would hire teachers or an administrator and provide the education at the jail. School districts and SEAs actually, have the ability to determine exactly how that would work under the IDEA. It could look like a number of things. It could look like, for instance, OSSI continuing to contract with Maya Angelou Public Charter School, and instead of DOC being the LEA, OSSI acting as the LEA for that period. There could be a number of different varieties in which to solve that problem, but that, for instance, could be one.
That's fascinating. I've never heard of a state education agency playing a dual role as a local education agency. I would be curious what legal ramifications might be implied by that, but that is super helpful. So by at least through August 2025, you would recommend maintaining this temporary structure and then looking for a more long-term solution. I also wanted to underscore and ask directly, have you heard reports of satisfaction with the services provided by Maya Angelou Charter School?
In terms of Maya Angelou's performance, I think that they are really trying to do the very best that they can, and they've done in our estimation, a pretty good job of trying to deliver the services. Again, some of the issues that we're seeing that one would typically think are the result of the failure of the school itself, have nothing to do with the school. So for instance, if we have a client who's not able to be taken out of their cell to be brought down because the DOC is lacking in transport staff, then that's not a failure of the school to provide the services. That's a failure of the DOC to make the student accessible for learning, or making the learning accessible to the student. Again, this wouldn't happen with typically disabled peers who are in the community, and that's really the comparator that we use. We're looking at the students' educational rights under the IDEA. I think that the staff at Maya are fantastic. Their hearts and minds are in the right place. They have a great team there. We support the work that they're doing, but it does become apparent when there are instances of a number of students who are still not receiving the services that they're supposed to receive under the settlement, or even just under federal or local law.
Thank you for that. And the settlement agreement called for compensatory relief for inmates. How has that played out at the DC jail?
That's a wonderful question. So the settlement agreement was executed in late September. During the fall, OSSI and possibly members of DCPS staff, though I think it was only OSSI, visited the jail, spoke to clients, asked them to make selections in terms of what they would like to use their compensatory relief on. Our understanding is that some class members made selections, others didn't. We heard a number of reports of confusion by class members about, who these folks were, what they were asking them about, what they were asking them to sign. We raised those concerns to OSSI. They have, tried to work with us to allay some of those concerns. We're currently, trying to, our team, our small team of attorneys at our nonprofit, we are also trying to enter the jail on a semi-regular basis to advise class members on an individual basis, one-on-one, of their rights under the settlement, and trying to help them, navigate this process. But it has been challenging. We look to the district for additional support on that effort. But as of right now, I am not sure that any class member has actually received any of their compensatory education award under this settlement.
Understood. But what I'm also hearing from you is there may have been some confusion or trepidation on the part of school members in signing documents and or requesting services. And so that is something we can certainly follow up with OSSI on.
Yeah, that would be great. And I think that is an accurate statement. I will just add a note that, a part of the settlement was the provision of a third-party auditor who and her team are hard at work trying to, also meet with class members, also explain some of these issues to them. And we have been in conversations about this very issue. So, we are working on it, and we are working with district government on this. But obviously we would always like that work to be a little bit more rapid, so that the young people can start using their awards sooner rather than later, because they do have a 3-year expiration date with certain exceptions.
Awesome. Thank you. Reverend Motley, I too want to thank you for your testimony and advocacy for more of the wraparound services that our young people so desperately need, from mental health services to libraries, as you mentioned. As we are entertaining the support for school members there at DC Jail, what would you recommend the council keep top of mind?
I think at the DC Jail, the first thing is literacy. We have to address the issue of the level of educational attainment in our city and those who are incarcerated. I'm reminded of when we were doing the DC jail program years ago. I was the keynote speaker at a GED graduation. And so I think it's important that the council really put literacy at the top, because we have to teach our young people, how to learn, how to read, comprehend, and then analyze. We did a creative writing before, and creative thinking. And so I think those are things that we need to really put at the forefront.
That really resonates. And I would say there has been a big push recently to deepen the district's focus on literacy and how reading and literacy is taught across grades. And it's something that we have yet to do at the scale that it requires. The science of reading, as some may call it, really is what you're talking about. How do we ensure a systematic approach to teaching all students, including students with special education needs, the skills and approaches to reading, so that they can be on their feet and grapple with society around them? And so I agree with you wholeheartedly, and look forward to advocating in this year's budget for ways we can accelerate literacy instruction across the board. Thank you all for your testimony.
Councilmember Parker, Councilman Parker, thank you for that question. Also, we have to be reminded every young person learns at a different level, they did a different approach. Some are auditory, some are visual. So we have to come up with ways to better teach individuals. So once we do the assessment of their ability, then we have to come up with the techniques to do that.
Hear you loud and clear. Thank you.
Thank you, Councilman Parker. So this hearing is concerning two bills, Bill 25-309 and Bill 25-461. 309 and 461 are very similar with regard to making Department of Corrections responsible for special education and allowing for the contracting with Maya Angelou. Bill 25-461 goes a little bit further, dealing with the Department of Corrections grievance process, which isn't really an education issue. What I did not hear from the witnesses was whether they prefer one bill over the other. So let me try that. Ms. Camo?
Yes. So I think I will detail this more in my written testimony. I'm sorry, I didn't submit it in advance. There are a couple pieces of language between the two bills that I think could be mirrored, because they're referring to things a little bit differently. But if we have to pick between one or the other, I prefer the LEARNS Act.
Okay, and I'm assuming, Ms. Bell, you would agree?
Yes, that's right.
And Reverend Motley, do you have a view?
No, sir. I confer to the young ladies that I think I appreciate their assessment.
But Ms. Como, is it that there is some language in the mayor's bill that would be better? And you'll put that in your written statement?
I think the language in Councilmember Pinto's bill is better than the language in the mayor's bill.
Okay.
The exact language is the best language.
Now, this legislation deals with provision of special education under the Federal IDEA Act. Should we broaden this legislation to speak about general education? Ms. Como?
I believe that every young person without a high school diploma inside DOC facilities should have the same opportunity to enroll in a high school and earn their diploma. That's a different undertaking than what the bill does, but I do think that is a huge priority. And being able to enroll in school, for example, if a young person, a 19, 20, 21, 22-year-old in the community wanted to go back to school and they didn't have special education needs, they could enroll in one of the state programs. They could enroll in Luke Seymour Academy, but that same young person in DOC facilities doesn't have an opportunity to access a high school diploma or to enroll in any high school. I think that's a huge issue, and I think it is something that council should look at.
Now, your answer kind of speaks to older individuals. Is that because that's what this legislation really is focusing on, is those who are older than compulsory education?
Yes, so anyone inside DOC facilities, so at DC jail or the correctional treatment facility, is going to be over the age of 18. They're going to be
No,
and
that doesn't necessarily follow. There are some individuals in Department of Corrections who are under the age of 18. Not very many.
oh, I was not aware. I thought under the Comprehensive Youth Justice Amendment Act, those Title 16 young people were in DYRS facilities. I was not
Well, maybe things have changed, but that's the way it was a few years ago.
So my understanding is under the Comprehensive Youth Justice Amendment Act, all Title 16 young people are held inside DYRS facilities. Upon their 18th birthday, they're transferred to the custody. Some of them are transferred to the custody of DOC. And so what you're seeing when you're looking at the DOC population is you have the older contingent of students with disabilities. So those are the 18 to 22-year-olds who are entitled to be enrolled in high school under the IDEA. But you also have 18 to 22-year-olds who don't have disabilities, who don't have any opportunity. So to answer your question, it would be amazing if this council decided to address the lack of education for all people inside DC jail and the correctional treatment facility. The compulsory age education piece does not provide the same rights to young people after age 18 as special education students have. So if you have special education, you're entitled to be in school, working towards your high school diploma and receiving supports through the school year in which you turn 22. So that is what allows those young people to enroll in Maya Angelou Academy. I hope that answers your question.
I think it does. Do you have a sense of how many youth we're talking about?
Ms. Bell would have a better sense of that number.
Ms. Bell?
Actually, I don't, but I can say that during the process of this litigation, it's been brought to our attention that there are a number of young people aged 18 and over who, might have previously even had special education rights, but no longer did because their special education services were exited, et cetera, or who never were even evaluated. So those would be some of the students who would possibly be in a general education program or didn't need special education services. We are aware of several of those young people who would typically or who would currently be considered general education students. But I don't have a precise number.
Okay. Can you provide us with a copy of the settlement agreement in Charles H?
Yes, absolutely. I can do that for all of the council to the COW and to the individual council members who are on this call.
Why don't you provide it? Well, you could do it to each of the council members at the hearing, but for sure to Councilmember Pinto and to me, since we are chairing the committees that are jointly conducting this hearing. Let me just see if I have any other questions. What the School Justice Project would like to see is continuity with Maya Angelou until September of 2025. But at that point, what would you like to see?
I think at that point, Chairman, typically again the most appropriate LEA at that point would probably be Aussie if there's no other LEA who can play that role. I'm not sure of Maya Angelou's willingness to play that role. There obviously at that point could also be a different education provider, though we certainly hope that that's not the case. And if so, then that would be the entity most appropriate to play the role of the LEA.
Well, what's wrong with what happened until this year, which was there was a contract with Maya Angelou, and as I understand it, they were the LEA.
Well, frankly, you would probably need to ask the government witness, DOC, and possibly OSSI about that further. There was a report issued by the district analyzing the options available to them. As I briefly mentioned earlier, the report ultimately found that the best choice for the district would be the Department of Corrections to play this role. We were not, we were interviewed for background information in that report, as well as I believe a couple other nonprofits or entities. But we did not have any meetings or any further conversations with the district on the outcome of that report and its findings.
Who did the report? I've not seen it. Who did the report?
I believe that the report was ultimately issued by either OSSI or the DME. I would need to pull it up. Sarah, do you recall? I think it may have been the DME. I can also send that along with the settlement agreement when I send that to the council.
It was issued by Students in the Care of DC, that office inside the DME, and it was in conjunction with I believe OSSI, DOC, the DME, the executive, and maybe DCPS's consultation. And they examined what entity would be most appropriate to serve as the LEA. And the options were three. I believe it was Maya Angelou is a public charter school, DCPS, or DOC. And they decided that but I think that we will provide you with a copy of that report and you can read it and see the options that they weighed.
Okay, that would be great. One last, in my remaining seconds, Reverend Motley, we spoke the other day, you made some comments to me about the role that some of the collaboratives could play. Do you want to say a little bit more about that right now?
Yes, Brother Chairman, thank you so much. I would also want to say to the young ladies, thank you for all of what you've contributed. And one of the things that I would like to see is UDC play a role in this as well, because back when we were dealing with this work, UDC was a partner, and they helped us with some assessments, both language and hearing. So I think UDC should be at the place. My thing about collaborative partners, everyone has to, actually do what they're supposed to do and work together collaboratively. We have too many silos that are not connecting the dots. And so I would like to see us, Brother Chairman, to do more collaborative planning as well as execution. And it starts at the top. So, we have to have everybody at the table.
Thank you. That's going to conclude the testimony from this.
Chairman, Councilmember Louis George is here, and I just have like 2 questions. I won't take the full 10 minutes.
My apologies. Please proceed.
Thank you, Chairman. And thank you to this panel of witnesses. Ms. Como and Ms. Bell, I wanted to ask you all, what are we seeing as far as evaluations that continue over time? So, for example, those who may be in the general education but need to have an IEP or haven't had an IEP, and so they're not sort of considered, they have not sort of had a IEP to diagnose sort of what their issues are. How is that? What are you all seeing as far as how it's working in the system right now? How are education evaluations happening over time? Are they happening over time?
So we've had a number of referrals come to us from young people inside DOC facilities that need evaluations, but because there's no mechanism to get them for those young people, it just hasn't happened for them. In the community, we've also had a number of young people, we've requested evaluations for young people, and we're seeing them be conducted and provided. It's not a hurdle in the community.
Okay. In what way is it an avenue through these legislations to direct a mechanism for continuous evaluation throughout a person's educational life?
Under the IDEA, the young people are evaluated every 3 years. It's called their triennial evaluation to assess whether their needs have changed, whether they still remain eligible for special education, whether they need different services or supports. There's also a provision in the IDEA that allows for you to request for an evaluation as conditions warrant. So if you think that something has changed, or if you think that a young person isn't receiving enough support, you can always request an evaluation as well. So I think in that sense, the IDEA really does cover that and provides ample opportunity for evaluation for young people. And I would like to say that Maya Angelou Academy has been doing a great job. We've had them conduct really comprehensive evaluations this year, and I've been really impressed with the level of service that they are providing to our clients after conducting those evaluations. I had one client who was classified as a student with one type of set of issues, and after an evaluation, everything for that student changed because we found that that student was misclassified for years and years and years and years and years, and was failing school every single year and was just getting passed along, and no one sought to evaluate him. So Maya was able to do that. And if we can just expand this opportunity, think how many young people will be able to access education and stop being passed along.
Right. That is what I was trying to get out, and that is what we're trying to prevent. Ms. Bell, I see you want to continue on that.
I'm sorry, I just wanted to briefly add that, and I think that my colleague may have alluded to this already, but to the extent that we could think about language that includes St. Elizabeth in this legislation, that would be hugely important for a lot of the clients that we have seen who would, but for their significant mental health needs that require daily and intensive treatment at St. Elizabeth, would be students who would be educated at the DC jail. Those group of students are not included currently in the legislation, but they truly should be. Those are people who need to be evaluated. We've had a couple of clients in that position. We know some of our colleagues in the education community have also had a couple of clients in that position. And while it's a small population, it's certainly not a population that we should be overlooking.
Absolutely. Thank you for that. Reverend Motley, I wanted to come to you. First of all, thank you for all the tremendous amount of work you do in our community and for special populations who need it most. I heard you speak earlier today about some of the ways in which preventative measures, literacy, libraries. I wanted to see if you could add any other sort of preventative measures and focus for DOC that we should be looking at.
Well, first of all, thank you, Councilmember George. You have been a shining star in our work in dealing with the issue of gun violence in our city. And you really supported the Jobs Not Guns effort. And so we want to also recognize that the young people that we're dealing with, and I like what the young lady said about St. Elizabeth. And so we have to have at the table all of the components, sitting down and planning. I talked to the chairman the other day, and he gave it a good assessment. So, Chairman, I said, we need to hear more of your thinking about this approach. The same thing with you, Councilmember George. You have a way of thinking about it, and you talk about it, but we need to hear it collective. We have to hear it so that we can make sense out of it, and then use all of what we hear in terms of these where you got diagnoses and prognoses, so that we as a community. So when we go to the barbershop, people hearing the same thing. We go to the library, we're hearing the same thing. And then I think we'll be able to wrap around this service, the problems that we're having in our city.
Got it. Awesome. Thank you so much. Thank you, Chairman Mendelson, and thank you, Councilmember Brooke Pinto as well for having me. And I will give my remaining time back to you all.
Thank you. Thank you for that gift. Co-Chair Pinto, do you have any other questions before we excuse the panel?
I do not. Thank you all very much for being here.
Yes, thank you. And
Thank you.
let me note the report from DME or OSSI. We do have a copy of that report, so you don't need to provide that. And thank you again for your testimony. We're going to turn now to the government witnesses. So you all are excused. The government witnesses are Katerina Simonova, and I apologize, I'll learn the name, Special Counsel for Policy and Legislation at the Public Defender Service for the District of Columbia, Danielle Branson, who's Deputy Superintendent in the Office of the State Superintendent of Education, and Tabitha Burnett, who's Education Divisional Administrator at the DC Department of Corrections. I have a statement from the latter two, but Ms. Simonova, I don't have your statement. And how do you pronounce your name?
Good afternoon. I'm Katerina Semyonova from the Public Defender Service, and my colleague Nikisha Winston should be joining, and I believe she's in the Zoom. Oh, I see her. And I will provide my statement in time for the record.
Okay, and your name is pronounced Semyonova?
Semyonova.
If I get that right. Thank you. Why don't you begin?
Thank you. Thank you for the opportunity to testify on Bill 25-309 and Bill 25-461. I'm Katerina Semyonova, Special Counsel to the Director on Policy and Legislation at the Public Defender Service for the District of Columbia. With me today to help answer questions is Nikisha Winston, Special Education Attorney in PDS's Civil Division. PDS strongly supports the Council's effort to ensure that students with disabilities who are in the custody of the Department of Corrections have access to education and the support that they need to thrive. PDS also supports the reforms that allow public trafficking of DOC's grievance process and urges the Council to take additional steps to streamline DOC's grievance process by shortening its timeline and number of steps, and thereby ensuring that residents can grieve matters during the course of their confinement. There's little doubt that education is a key component of success in reentry and in life. Finishing more years of high school, and especially earning a high school diploma, decreases the risks of premature death, increases employment, and lifelong earning potential. Full-time workers with a high school diploma earn 24% more than workers without a diploma. This is a critical point as the district faces an affordability crisis and a staggering wealth gap between Black and white families. Education at the DOC, where nearly 90% of the population is Black, is one part of addressing pervasive racial disparities in the district. Employment and wages also contribute to housing stability and community stability, all of which begin with education. Success along these metrics is passed between generations. Children in more economically secure households have a chance to grow up with less poverty and less trauma. Education also has a major role in protecting against recidivism. According to a 2018 study funded by the Department of Justice, incarcerated individuals who participated in high-quality educational programming were 48% less likely to return to prison within 3 years than those who did not. Data from the fall of 2023 shows that at least 25% of the men held in Department of Corrections custody reported not having a high school diploma or a GED. Many of those individuals are young people, ages 18 to 22, who, if they have disabilities, have a right to education under the IDEA. Under the IDEA, the district is legally responsible for providing a free, appropriate public education to students with disabilities in its custody, including those at DOC. Disabilities for these students include intellectual disabilities, learning disabilities, and serious emotional disturbances. As a result of being failed in school systems and having learning disabilities and differences treated as disciplinary problems, young people with disabilities are drastically overrepresented in the criminal legal system. Rather than encountering help, these students are often pushed out of school. The data shows their overrepresentation, with the Bureau of Justice Statistics finding that 32% of state and federal incarcerated persons had a disability compared to 15% of the general population. If students with disabilities who are in the custody of DOC do not receive appropriate educational support, they will fail to graduate from high school, and they could be sent to the Bureau of Prisons without a GED or a high school diploma. The BOP does not provide any meaningful support to students with disabilities. This will leave students with disabilities in the BOP without the ability to then earn a GED. Without a GED or high school diploma, the district students with disabilities will not be able to progress through the BOP's recidivism reducing programs, such as UNICOR. They will also be excluded from other vocational and educational programming in the BOP. Even if students with disabilities are released from DOC to the community, if they do not receive high-quality education while in DOC custody, the district will lose this valuable opportunity to provide support that will increase employability and decrease the possibility of recidivism. Helping students with disability make educational progress while they are in custody of DOC is vital to their lifelong success and the success of our community. The two bills before the council give students with disabilities important tools for progress. Bill 25-309 provides that DOC will be the public entity responsible for providing a free, appropriate public education under the IDEA. While there may be other models for ensuring access to education, such as creating a separate local educational agency that serves incarcerated students with disabilities, identifying DOC's role in the provision of education is an important first step. However, to ensure stability, instead of only 1 year, the council should extend the period covered by the legislation for 2 years to 2026. The LEARNS Act also takes the important step of allowing students to be identified as having disabilities during their detention at DOC. It does not limit the provision of special education and related services to students who enter DOC with a diagnosed disability. This is a critical part of ensuring progress in educational attainment for some of the district's most vulnerable students. Many PDS clients have their first educational or psychological evaluation as a result of their involvement in the criminal legal system. Despite the requirement that all public and charter schools must identify students with disabilities, countless students are failed by the system and are not identified as having disabilities until they are involved with the criminal legal system. These students with disabilities often face disciplinary consequences as opposed to getting the testing and help that they need. Or students move between schools or miss school days as a result of trauma and family circumstances and are therefore never identified as having disabilities. Often, even if they are tested, students are misdiagnosed as not having a disability. These students frequently perform many years below grade level and have significant educational deficits. Without appropriate services and dedicated instruction and the earliest intervention possible, these students will likely face insurmountable challenges in attaining a high school diploma or a GED. It is therefore critical that these students and their lawyers are able to request evaluations for disability. It is also important that individuals who have been previously assessed for disabilities continue to have the right to a future assessment. As currently drafted, students who were determined not to have disabilities will not be evaluated again at DOC, even if the first evaluation was years earlier or the diagnosis was incorrect. Disabilities may develop over time, and the IDEA's definition of disability includes students who have emotional disturbances that are a barrier to education. Emotional issues also develop over time and can be the result of trauma, and therefore students should not be limited to a one-time evaluation. In order to ensure that all students with disabilities who are in the custody of DOC are afforded the chance to access appropriate education and related services, PDS has statutory amendments that it would offer in written testimony, providing that the attorney for the individual can also request the evaluation and not limiting any of the evaluations to students who are not previously assessed for special education services. As the district works to ensure that students with disabilities receive an education consistent with IDEA, students with disabilities who are in the custody of St. Elizabeth's Hospital should not be overlooked. At any given point, there could be several students with disabilities at St. Elizabeth's who are under the custody of DOC. These students may be ordered there for competency evaluations or testing consistent with an insanity defense. They should be covered by the legislation by amending the text. The LEARNS Act also codifies requirements for contractors seeking to provide services to students in correctional settings. It is important that the district provide detained students with high-quality education opportunities and that contractors have deep experience in the district and with detained population, as well as a commitment to in-person education. PDS supports all of the qualifications provided in the LEARNS Act and appreciates the council's thoughtfulness in establishing these standards. Legislating in a different space, Section 10 of the LEARNS Act addresses tracking grievances in the DOC. These changes are important and they are positive, but they are not sufficient because they fail to address the DOC's grievance process, which is too cumbersome, too long, and has too many steps, and that therefore deprives residents of a meaningful opportunity to grieve the conditions of their confinement or other matters while they are in DOC custody. PDS testified about the need for reforms to the grievance process at the DOC oversight hearing in February 2023. This legislation does not make the reforms requested there. or at least not in its entirety. The legislation aligns with changes that DOC has been making to its internal process of tracking grievances. It is certainly helpful to the public to have these grievances tracked. It is helpful to the attorneys. It is helpful to incarcerated individuals. But it needs to be easier for individuals to file grievances while they are in DOC custody. So beginning with the positive, the tracking of grievances is positive. It provides more information to the public, such as contact information for DOC staff, as well as information about the rights of individuals. But these improvements will mean little if the council does not improve and streamline the grievance process. The grievance process is the vehicle through which DOC residents must seek redress. It has to start there. Having contact information or more transparency for the progress of the grievance will not shorten the length of time that it takes for residents to complete all of the steps. DOC already has the authority to create policy for receiving and responding to residents' grievances. The grievance process that DOC has chosen to create has 4 separate steps that residents must go through before they can reach a final resolution. Each step requires the resident to submit paperwork that they received from DOC in the prior step. Each grievance filed can only include one issue. A resident grieving inadequate food, a lack of programming, a lack of hot water would have to file 3 separate grievances. The deadlines for responses by the resident vary depending on whether DOC responded to the grievance. Even if a resident moves to the next step of the DOC grievance process, as soon as DOC is required to respond, the DOC process still takes a total of 80 business days, meaning a minimum of 112 calendar days to get to a final resolution. The process takes longer than 112 calendar days if any holidays fall within that time period, or if DOC requests an extension. This timeline denies many individuals the right to a resolution. DOC's own data shows that approximately 58% of women have a length of stay that is less than 91 days, and 45% of men have a length of stay that is less than 91 days. Just by virtue of how long it takes, DOC grievance process will deny the majority of detained women the right to grieve the conditions of their confinement. DOC's grievance policy is also out of line with other jurisdictions. For example, in West Virginia, the Department of Corrections has a grievance process that involves 3 steps and takes 20 days to reach a final resolution. PDS has raised these issues regarding DOC, has raised them with DOC and to the council. And it has not led to a reform of the number of steps and the length of time. The council should step in and act and legislate in DOC's authorizing statute to amend this. And these reforms can also be included within this legislation. Thank you, and PDS welcomes any questions.
Thank you, Ms. Semyonova. Danielle Branson.
Good afternoon, Chairman Mendelson, Chairwoman Pinto, council members and staff. My name is Danielle Branson, and I am the Deputy Superintendent of Academics and Schools for the Office of the State Superintendent of Education. In this role, I oversee 4 divisions: Health and Wellness, Systems and Supports, also known as K-12, Teaching and Learning, and Post-Secondary and Career Education. Formerly, I was a special education teacher here in the district, as well as the Director of Assessments and Deputy Assistant Superintendent for K-12 at OSSI. I am joined by Victoria Glick, our Director of Special Education, who has deep content expertise in special education and the Individuals with Disabilities Education Act. I welcome this opportunity to testify before you today on Bill 25-309, Special Education for Young Adults in the Custody of the Department of Corrections Amendment Act of 2023, and the provision of special education services for justice-involved young adults. OSSI plays 3 important limited roles in the provision of special education services for justice-involved young adults. First, OSSI provides strategic support. In 2022, from June through September, OSSI, in its role as a state education agency, and in partnership with the Office of the Deputy Mayor of Education, convened a task force of relevant stakeholders to identify challenges in the provision of these special education services and chart a path forward for the delivery of appropriate services. The task force engaged in a deliberative decision analysis protocol to evaluate the options available for ensuring the provision of special education services required under IDEA for justice-involved young adults. We are proud of the transparent cross-agency discussions of the task force, which included representatives from the DME, OSSI, the Department of Corrections, the Office of Students in the Care of DC, St. Elizabeth's Hospital, the DC Corrections Information Council, the Department of Youth Rehabilitative Services, the Department of Behavioral Health, and the District of Columbia Public Schools, the Public Charter School Board, and the Office of the Attorney General. By convening these stakeholders, we surfaced shared values and important considerations to guide the district's paths forward. After considering 4 options, the task force collectively ranked DOC as the most appropriate public agency to provide special education to young adults in its custody. Please find the task force full report detailing all considerations and conclusions attached to our written testimony. Second, OSSI provides technical assistance. This assistance has included supporting DOC with the development and administration of their contract with the C Forever Foundation. We continue to support the administration of this contract through a memorandum of agreement between OSSI, DOC, and the C Forever Foundation, and through quarterly meetings to address procedural and programmatic needs designed to ensure delivery of a quality education. Third, as required under federal law, OSSI monitors and oversees the implementation of IDEA requirements in all public education settings, including for justice-involved young adults. OSSI conducts quarterly monitoring activities, and we regularly do on-site visits and interviews with students, school staff, and DOC staff at the DC jail. If necessary, OSSI provides corrective actions and ensures all parties work together to remedy concerns. Federal law provides significant guidance on the provision of special education for justice-involved young adults. Under IDEA, adults 18 to 22-year-olds with an individualized education plan, or IEP, who have not yet graduated from high school are entitled to receive special education services while detained if they consent to receive those services. However, IDEA specifically carves out this entitlement those who arrive at jail without an IEP or active eligibility for services, meaning that states are not required to locate, identify, or evaluate adults for potential disabilities while detained. OSSI appreciates that Council, in accordance with the task force's recommendations, passed emergency and temporary legislation designating the Department of Corrections as a responsible agency for delivery of special education to individuals in its custody for this school year. Bill 25-309 is a permanent bill to designate DOC as a responsible agency for the duration of the 2023-24 school year. This necessary legislation enables the Department of Corrections to identify and contract with expert service providers to deliver needed special education services to young justice-involved adults. While OSSI must continue our diligent oversight of special education in the DC jail, we have observed marked improvements in the delivery of these services under the current operating framework. We urge Council to expeditiously pass Bill 25-309. Thank you for the opportunity to testify on this important bill today. Director Glick and I are pleased to answer any questions you may have.
Thank you, Ms. Branson. Tabitha Burnett.
Good afternoon, Chairperson Mendelson and Pinto, members and staff of the Committee of the Whole and Judiciary and Public Safety. My name is Tabitha Burnett, and I'm the Education Administrator for the DC Department of Corrections. As Education Administrator, I am responsible for overseeing all high school diploma services, secondary, post-secondary, and career education at our DOC facilities. I have served in the education space at DOC for almost 6 years, and before coming to DOC, I spent several years as a teacher. I am before you today to give testimony on B25-309, Special Education for Young Adults in the Custody of the Department of Corrections Amendment Act of 2023, and B25-461, Leading Education Access for Reentry and Necessary Success, LEARN's Amendment Act of 2023, and more generally to discuss the provision of special education services to those residents in DOC's custody and housed in our secure facilities. First, I would like to talk about our education programs at DOC. The DOC Education Department provides transformative educational opportunities inclusive of the support systems needed for successful reentry. Our education services range from high school diploma services, adult basic education, GED, career technical education, post-secondary, credit and non-credit bearing courses, and career readiness education. All course offerings create multiple entry and exit pathways to accelerate access towards individual academic interest and reentry needs. Currently, special education services are provided by our contract with the Maya Angelou Academy at DCDOC. Maya Angelou Academy is an alternative school for young adults housed within DCDOC facilities. Maya Angelou Academy works in partnership with the DC Department of Corrections to provide a free, appropriate public education rooted in the Individuals with a Disability Act for residents ages 18 to 22 who have an individualized education plan. This past year, Maya Angelou Academy serviced 45 students where 97% earned credits towards their diploma and 9 earned their high school diploma. I now turn specifically to the bills. DOC is supportive of B25-309, which would designate DOC as the public agency responsible for the provision of a free and appropriate education for the duration of the 2023-2024 school year. As council is aware, in August 2023, DOC entered into a contract with the See Forever Foundation to provide special education services to eligible residents in our DOC secure facilities for the 2023-2024 school year. DOC is both willing and able to continue to serve as the public agency responsible for FAPE as provided through the contract with See Forever for the rest of the school year. With regard to B25-461, DOC would note that we are committed to working with our educational partners, both in district government and outside, to ensure that those who are eligible for special education services receive them while they are in the agency's custody. We are, however, conscious of the need to be prudent when it comes to resource utilization, so DOC will continue to work with our government partners to determine the best way to meet educational requirements while also being good financial stewards. The current contract for special education services is $4 million, and we must carefully evaluate any additional requirements that will add to those costs. That includes those in this bill that add expansive evaluation and assessment requirements. In closing, I would like to state that DOC is committed to ensuring that we not only meet our federal requirements related to special education services, but that we provide comprehensive education opportunities for those who wish to avail themselves of them while at our secure facilities. Thank you for providing this opportunity to testify on bills B25-309 and 25-461 and to speak about education at the DOC. I'm available to answer any questions.
Thank you, Ms. Burnett. We'll follow the same order as before. So Council Co-Chair Pinto, do you want to start off?
Sure. Thanks, Mr. Chairman, and thank you all for your testimony and for being here today. I want to start with you, Ms. Burnett. Can you provide a brief overview of the current education programs that are available across the correctional facilities and articulate what types of educational services are being offered specifically to address the diverse educational needs of our students?
Yes, of course. So we currently provide special education services, as we've discussed today, with our See Forever Maya Angelou Academy contract. So all of our students that enter our care that qualify for services, they are screened at intake, and those that are eligible are actually moved over to one of the designated learning areas, as we've discussed with the new implementations from Charles H. Those that do not qualify for high school diploma services have an opportunity to basically enroll in anything that meets their academic pathway, whether that's adult basic education, GED services, CTEC classes. I know that you've been able to join some of those classes with us, as well as any of our post-secondary services, which include credit and non-credit bearing courses. Those are offered through our partnerships with Georgetown, Howard, UDC, Ashland, one of our distance-based learning, and several others. We as well have our career readiness education. So we do a lot of work with just preparing our residents for reentry through curriculum like National Corrections Works, as well as we have several industry certifications that we provide that will prepare them for the workforce specifically.
Thank you for that. And to what extent is there parental involvement when there is a student with a learning disability who needs additional services and a particularized type of education?
That's a great question. So parental involvement is very limited in our role. We work more closely with the advocates, many who are with us today. Very rarely will I hear directly from a parent. If they do contact us, specifically the DOC, then usually we will work collaboratively with our partners at OSSI or any of their education advocates to ensure that we have the documentation as needed. But I would say, to answer your question directly, it's very limited.
Do you see any opportunity for increased involvement with parents?
I have a pretty open door policy. If they contacted and wanted to discuss their education opportunity, happy to discuss what their options are. It doesn't happen as often, but it is possible.
Okay. Well, I think that that's an important part as we ensure that, especially for the population of students that we're talking about that might not have already been assessed, and adding that requirement to ensure that folks are assessed for an IEP. Parents or families may have specific knowledge or awareness or ability to advocate on behalf of their child. Is there any reason why DOC should not be the agency responsible for providing FAPE to eligible students?
I think to answer that question in the larger holistic response that you would require, I would best defer that to Deputy Mayor Appiah and her office for response.
Okay, I guess just as we are crafting this legislation and making sure that it can be implemented most effectively, it's important to know that the agency will be able to implement it. So maybe asked a different way, are there any hurdles that you foresee in implementing this legislation as currently drafted?
The short answer, infrastructure and resources.
Okay, and is that something that could be accomplished through adding funding?
I would say yes.
Okay, and is that because there needs to be additional staffing to do the IEP assessment itself?
Yes, absolutely.
And how much additional staffing do you anticipate that would take?
The extensive processes that go into the evaluation process, the initial assessments, we would look at the full implementation of what would be a diagnostic center, which the staffing there, I don't have a number. DOC would have to get back to you on what that would look like. But it would be a substantial amount of new staff that would be needed.
Okay, and so I don't know if you've heard the back and forth with some of our public witnesses, but we're trying to get a sense of how many students particularly are currently being served or would be additionally served under this change. And I heard in your testimony, you talked about 45 students.
Mm-hmm.
Do you have a sense of how many additional students would be eligible for a FAPE and for this specific IEP testing, as we try to back into how much additional staffing that may take? It's only a couple of students out of 45 that will help advise us.
I do not have that information.
Okay. Well, that's something that we should get in advance of moving forward, or as we move forward, to get an accurate sense of how to ensure this can be implemented and what is reasonable for additional staffing, especially if there are a limited number of students who are going to be qualified for this testing. Okay, going back to the contract and ensuring that there's not a gap in services, how will your office work with OSSI and the Deputy Mayor for Education to ensure continuity of education between contracts?
So we work closely with both offices, DME and OSSI. We meet weekly. We have met to discuss the MOA that's currently been executed for this school year. I would say right now we work, one of the words I will use just that I'm really proud of is that all sister agencies work really collaboratively together. And we are in constant communication to ensure that that does not happen.
Okay. Thank you for that. And Ms. Seminova, I want to talk to you a little bit about the grievance process. And I heard in your testimony that there are ways that this could be improved to make sure that it's not only as transparent as possible, but as effective as possible. Can you first articulate kind of what some of the gaps are currently in the grievance process? And then hopefully we can have time to talk a little bit more about improvements you'd like to see.
Sure. It's not too much of a gap as it really takes too long. There are too many steps. The steps are too cumbersome. Whether an individual has to respond depends on whether DOC responds, how much time they have to respond. It's a 4-step process to get to a final resolution. And at each step, there are many days. It's convoluted. It's convoluted, indirect, and unnecessarily lengthy. So it's really a question of simplifying it to 2 steps. Even 3 steps would be an improvement, but 2 steps would be ideal. There should be a grievance process, an answer from DOC, and then an appeal. And then once DOC answers that appeal, that should be the final decision by DOC, sorry. And that should be the end of that process. It should not take 80 business days. It should not take 112 calendar days. It should be something that works quickly.
Okay. And Ms. Burnett, do you have a response to that in the implementation of a easier to follow grievance process?
I do not.
Okay. Go ahead.
I would just add that I think we discussed this with Director Faust at the 2023 hearings, and that there had been some promise of maybe working on it to shorten it, or potentially looking at it. I'm going from my recollection here, but that this is really, it's a streamlining. It shouldn't be any more difficult for DOC to in fact cut the process.
Okay, thank you. And yes, I do recall we talked about that performance oversight hearing. And so hopefully we can also have an update from DOC when we hear from Director Faust in a couple of weeks for DOC's performance oversight. Thank you all very much. Thank you, Mr. Chairman.
Council members, since you're co-chair, and I'm not thinking that we'll have a second round, do you need some additional time?
I think I am okay. I think that some of the grievance process issues will need to follow up with DOC on, but I think I'm all set for questions. Thank you all very much.
Thank you. Councilmember Parker.
Thank you, Mr. Chairman. I'm going to start with you, Ms. Semenova. You testify that you recommend extending the timeline by 2 years so that the Department of Corrections has legal oversight until 2026. Given our earlier conversation with public witnesses, what would you recommend after that 2-year period in terms of who would manage the educational services at the DC jail?
You know, we don't disagree with School Justice Project, with Ms. Bell and Ms. Como, that there are better models, that corrections does not have the expertise in this subject matter. I don't know if Ms. Winston wants to add to that in particular, what should be envisioned, but the goal for 2 years, and it's not very different from what I heard School Justice Project testify to, which was August of 2025, and we suggested just 2020, getting to 2026. It's for stability, for planning, for continuity.
To make sure I'm interpreting correctly, so you don't necessarily have a recommendation of what should come next, but would advocate for continuity through 2026. Is that accurate?
That's accurate. And maybe Ms. Winston has ideas about sort of some of the kind of the the ideas that should guide what comes next rather than an exact recommendation for what comes next.
We just wanted to point out that the task force that was convened did not include any advocates or people directly representing clients that were going through the system. And so in the meantime, while we're waiting for 2016, it would be helpful if there was like a task force that looked into other options. For example, in Maryland in 2021, they established a juvenile services education board that basically is an LEA for anyone in correctional education in Maryland. And they like have an MOU between their Department of Juvenile Services and this board. And so we could explore something similar like that. So I think we should use that time to actually explore other options and actually have folks that represent some of the students involved be a part of these discussions and sort of flesh out what could be the most appropriate LEA. I think that the DOC is appropriate for a public agency to ensure FAPE, but we do need to identify an LEA. That's important for funding purposes, et cetera.
Thank you for that. And I'm going to come to you next, Ms. Branson, with a similar question. You mentioned the task force selected the Department of Corrections to administer education services at the DC jail. Can you summarize what the task force used as justification for that decision?
Absolutely. Thank you so much for this question. So as you referenced, OSSI and the DME co-led this citywide task force to identify the state public agency to support sustainable correctional education program for students with disabilities. And as you stated, the outcome of which was DOC. This is a multi-month engagement with 11 agencies and collectively decided that DOC was the most appropriate agency to be responsible for these services, similar to how DOIRS is responsible for education services for individuals in its custody. And some of the kind of critical decision-making factors in here were the structures, operational processes, and access to our justice-involved youth that are unique to DOC. We stand by the task force decision and to let the current process stabilize, as we've heard from other testimony, before making any amendments or drastic changes. One thing that's important to call out here as we think about identification of DOC as a state public agency is that this framework enables them to contract with an expert education service provider with the C4Ever Foundation currently, as we've noted. This framework enables OSSI also to monitor the quality of education provided. And thus far, we've observed that this current framework is working well, as you've heard testimony about graduation rates and credit attainment increasing. And so we also want to note that IDEA also explicitly contemplates and permits the state public agency, such as DOC, to be the responsible agency for these services. This is a common framework nationally. For further oversight, as you've referenced, expertise in special education services, of course, there is this expert education service provider, but we also have a memorandum of agreement that ensures that OSSI maintains its ability to oversee the quality of implementation in partnership with this SPA responsible for the educational services.
Thank you for that. In terms of the timeline, we've heard recommendations for revisiting the responsibility of education services at DC Jail for August 2025 and 2026. While I know you are probably not in a position to make that determination, are there processes available that would allow you all to rethink who should have oversight of those education services when the time comes?
I certainly think, Dan, thank you for that. Right now, we stand by the deep analysis that was conducted during the task force meetings, noting that additional discussion and expertise as we iterate over time, it has value, but we believe that the structure of the SPA with the contracted expert educational service provider with the oversight from the state education agency is a very solid model. Right now, any disruption to that puts at risk the quality of services, and we believe that stabilization of this new process is really critical.
Quick follow-up question, and you may have to follow up with the committee after fact. Are there any legal implications to OSSI being the state education agency and playing an LEA type role at the DC jail?
Thank you for that question. As a state education agency, OSSI must be able to provide oversight over all of our LEAs and all of our educational programming. If OSSI were to be in the position of also operating as a state public agency, it would remove the important checks and balances the state education agency is established to ensure. So that critical oversight and monitoring role is another primary reason why we want to have that separation of OSSI overseeing all services and having a state public agency serve the direct service portion in partnership with an educational service provider.
I got you. And one more question. Earlier, I asked about compensatory relief that had been predetermined for student members at the DC jail. How is that relief being managed, and what type of oversight is OSSI conducting to make sure people at DC jail are receiving services?
Thank you so much for that question. And we can absolutely respond. I'd like to call in Director Glick, who manages that program.
Good morning, and thank you for the question. OSSI is working closely with the Plaintiffs' Counsel, who testified here today in part, along with our co-identified third-party auditor, Ms. Lopes, who is an expert in the correctional education space, and with the Public Defender Service, specifically Ms. Winston, to support, and her colleagues, to support the delivery of the compensatory services to students who are members of the class. We're deeply engaged in ongoing conversation with the class members around their interest in receiving the awards, and we're committed to the partnership endeavors to ensure that the district is complying with the settlement agreement. So that work is ongoing and actively managed at this time by OSSI.
Thank you. And I think your last name was Glick, is that right?
Yes, it is.
Okay, Ms. Glick, I'll ask a different way. Can you reassure us here at the council that there are no student members at the DC jail that have not received compensatory relief or are in the process of receiving those services?
Yes, I can absolutely assure you. I have met with every individual at the DC jail who's entitled to these services. I've made offers to them. I've discussed those service availabilities with them, and the district is working closely with Plaintiffs' Counsel to provide access to their clients in the case, to provide counsel on how to receive those services. And so those engagements are ongoing. We're also tracking to that data and reporting on it to the third-party auditor and to the Plaintiffs' Counsel on a monthly basis. And so I can assure you that we've dedicated staffing, resources, data system activities, and continuous reporting activities to ensuring that all of the commitments in the settlement agreement are undertaken with fidelity.
Awesome, thank you. And we're about a month or so away from oversight hearings, and I imagine we will follow up then about that. I want to use my last 30 seconds with you, Ms. Burnett. We heard earlier that there was an example with Maya Angelou providing services at the DC jail with some student members that were detained or not able to come downstairs for educational services. What types of interferences exist that might preclude students from receiving their educational services on a day-to-day basis?
Thank you for that question. So the reasons that a student would not be able to go to the classroom space specifically for that day would be extremely limited, and it would almost always be just a safety or security concern. Those are well documented. I'm made aware of those situations. I work closely with See Forever, Maya Angelou Academy, to ensure that if that is the case, what are our alternative options for providing the students their instructional hours or related services. I cannot think off the top of my head where there's just one reason where a student would not be accessible to the classroom space with the in-person instructor, unless it were a safety or security concern that had been addressed with myself as well as Maya's administration on site.
Okay, thank you. That is my time. Quick follow-up. Is there any log or data you have for the last, let's say, 90 days that you could detail for the committee, the number of student members and the days that they've received educational services at the DC?
Absolutely.
Okay, if you could share that, that would be great.
Thank you, Councilmember Parker. And sharing that, you should send that to Councilmember Pinto as well as to myself. as well as to Mr. Parker. So I'm going to ask a stupid question, and that is, what is an LEA, Ms. Branson?
Absolutely. So thank you for the question. Our local education agency responsible for educational services to students in schools. There has been some discussion about a local education agency versus the SEA versus a state public agency, all of which are good questions. As we're thinking about the responsible agency for educational services for students who are justice involved in this setting, IDEA contemplates a number of different pathways. All of those were considered during the task force, or many of those were considered in the task force conversations, be it an LEA, the SCA, a state public agency, or a new agency to be developed. IDEA contemplates multiple pathways. The structure of the state public agency versus the LEA, both are options that are available to us. So we have recommended and moved forward with a state public agency with an educational service provider providing direct services with oversight by the state education agency.
Now, OSSI licenses LEAs, correct?
We are responsible for the oversight of our local education agencies.
Okay, are they licensed?
No, the Public Charter School Board is the authorizer for our charter schools, and the DC Public School System is responsible for licensure for our DC Public Schools.
Okay, so there isn't a licensure requirement to provide educational services for justice-involved youth.
For justice-involved youth, again, we have a structure of creating, there are educational requirements within that setting, but for the purposes of this conversation, there is no licensure requirement for OSSI.
Okay, and the pathway, to use your word, that we have here is a state agency or a public agency, that would be Department of Corrections, which in turn then contracts with an educational provider, which in this case is Maya Angelou.
Mm-hmm, that's correct.
What about other educational services that are provided at the jail?
I would defer to DOC for the more detailed conversation about the services that they provide educationally. But for this frame, the structure we've set up for special education services is something where OSSI monitors our IDEA requirements, have gone through the structure of the SPA and with the education service provider. But I would defer to DOC for—
Well, I'm not so much asking what the services are, but rather, is this something that OSSI then monitors, just as you monitor charter schools and other LEAs?
We monitor the IDEA requirements for services at the jail for students receiving special education services.
And there's not any requirement that with regard to other educational services provided by the Department of Corrections that OSSI has to monitor those?
We do not oversee, we do general monitoring across. So we can speak to general monitoring and then special education monitoring, but there are additional monitoring of the adults in the setting that DOC does.
Okay. So let me shift a little bit here. In your testimony, Ms. Branson, you concluded by saying we urge the council to expeditiously pass Bill 25-309. I recognize that that's the bill that the mayor introduced. Bill 25-461 is very similar. Of course, it goes a little bit beyond talking about the grievance process, and I'm not asking for your view on the grievance process. But does OSSI have a firm view of 309 versus 461? And if so, why?
Thank you for that question. We believe that council should focus on codifying the Department of Corrections as a responsible agency for the delivery of special education to young adults in this custody. So Bill 25-309, we believe, is needed to ensure that the contract between Department of Corrections and See Forever is on solid footing for the rest of the school by, thereby ensuring that these justice-involved young adults receive the education they're entitled to under federal law. We believe the LEARNS Act goes a bit above and beyond what is needed to successfully provide quality special education services to justice-involved students with disabilities. And we believe it's premature at this time to add requirements that go above and beyond what's required by federal law and IDEA that increase complexity, cost, additional legal liability before the new educational framework is stabilized. We believe that stabilization is critical and is spoken to in 25-309.
So 461 does the same thing in that it authorized mandates Department of Corrections, but it goes further in requiring, for instance, these assessments of those who've not been previously assessed as special needs. Am I understanding you correctly?
Yes.
And do you think that going further at this time is not prudent, in part because of cost, but you mentioned also liability?
Yes.
Want to say more on that?
Absolutely. Thank you. Before the additional framework is stabilized. And this is referencing the child find call out that is a requirement in IDEA. And this is a process that is much more expansion than the evaluation process itself. Under IDEA, Child Find is a system to identify and locate students who might have a disability and evaluate them to determine if they're eligible for special education. And this applies to LEAs like DCPS and our charter schools, but does not apply to state public agencies like the Department of Corrections, and may not be needed for what council is seeking to accomplish with a maybe broader and referral-based evaluation system. By activating Child Find, council is activating much more than is contemplated by the LEARNS Act, including a system that is most applicable to young people in an LEA.
And the term you used was child find?
Yes,
And that's a term within IDA?
it is.
That's very helpful. Let me see. So what would be the plan after? So the Bill 25-309 covers a year. Am I getting that right? Somebody answer me here, maybe Ms. Branson?
Yes.
It covers a year. So, and then Ms. Samianova suggested that it be run until, I think it was 2026. Either way, what happens at the end of this? Ms. Branson?
Yes. Thank you for that question. So as we stated before, we stand by the decision from the task force where we are having a structure of the state public agency as a Department of Corrections moving forward with an educational service provider. So we stand by that recommendation for the reasons I've already discussed.
So that would be a permanent solution.
We would be open to that as a permanent solution.
Well, that's my question. And the bill's, as I understand from the testimony, is not a permanent solution. It's a pathway for the moment. But you're saying that you think it should be permanent.
I'm saying that that is yes. I think the structure that we've outlined is a really strong structure that has a lot of checks and balances and appropriate and clear responsibilities at multiple levels. I think it's really important, and we think it's important to give ourselves time to stabilize. And we haven't set a particular date on number of years, but could revisit after a certain time once stabilization of high quality services is able to play out, which I know you have heard a testimony to that nature from a number of parties, and we agree with that.
In your statement, Ms. Branson, you said on page 2 under federal law, however, IDA specifically carves out of this entitlement those who arrive at jail without an IEP or active eligibility for services, meaning that states are not required to locate, identify, or evaluate adults for potential disabilities while detained. Is that the same as what you said a few minutes ago about Child Find, activating Child Find?
Yes.
I'm just checking to see if I have other questions. I have other questions.
Chairman, I'm here, by the way, and I'll likely return time to you.
We don't keep a cumulative clock.
I thought that would get me a gold star. I'm disappointed.
The box of gold stars ran empty last week. There was a lot of really good witnesses. Not to say that today's witnesses aren't really good. I don't have any other questions at the moment. Councilmember Lewis George?
Thank you, Katarina. I hope I'm saying that right, Attorney Katarina. Thank
Yes.
you. Can you discuss PDS's role or a youth attorney's role in this process and any gaps that you are seeing with involvement or access?
Absolutely. And I'm going to turn to Ms. Winston to answer that.
Okay. Hi, Ms. Winston. Thank you.
Hello. So I'm a special education attorney for the Public Defender Service. And if a student has wants their high school diploma, the only way they can currently access that is to have an IEP. And if you haven't already been found eligible, there's nothing you can do. So there are clients that have like 2 credits away from graduation, and they have nothing they can do other than a GED. And oftentimes you can't access GEDs or adult basic education because you're on a unit that maybe is a maximum level unit where there's not very many programming available, or you just need extra help. And like some of the public witnesses have said, oftentimes the disability category may be wrong, and so people need to be reevaluated. They may have been found not eligible previously, and now we have new information because we have new evaluations that happen because of their court involvement that show they actually do have a disability and explains why they failed all these times. And so, for those students with IEPs, I can get them evaluated. I can get them services. I can get them reevaluated. Or if there's new disabilities that pop up, I can then have an IEP meeting to discuss those. But for those students that aren't currently found eligible, there's just nothing you can do for them. They just languish when it comes to education, unless they happen to luckily be on a unit that does have programming, but not every unit has programming that's accessible to them. And if you have a disability, then even if you are in the programming, it's not really accessible unless you get the real specialized instruction and the related services in order for you to be able to access that curriculum.
Got it. That appears to me just to be such a huge gap. And we know it's happening without a doubt. I think all of us can acknowledge that we know that it's happening. There are children who are flying under the radar for so long that we know that this is occurring. As far as delivery of services go, current delivery of services, future delivery of services, given that, what are you all seeing as far as best practices for delivery of services and ways that delivery of services, educational services, can be improved?
I think Brian Angelou was doing actually a really good job. The only problems I run into are structural problems, sort of institution problems, sort of when someone is in a restrictive housing unit, they can only have a certain number of folks out at the same time on your restrictive housing unit because they chain them. There's like these chains to the floor. And so there's only a certain number of people can be out at the same time. Since everybody can't be out, you don't get the same number of hours of someone who is actually on a school-based unit. So there is a high school block, and those students tend to get hours similar to what they would get in the community. But if you're not on a high school block, particularly if you're in a restrictive housing block, you don't get the hours you would receive out in the community purely for structural reasons that they can't have everybody out at the same time. And so those students do miss out on getting all the services they should get, and as well as even getting the related services, having related service providers come along. Certain related service providers can go in certain units, and sometimes I've had clients just go without because they weren't able to get to them on their unit.
Okay, thank you. That's really helpful. Asi, can I come to you? How do you, Ms. Branson, how do you see Asi's role while DOC acts as the LEA? I know you mentioned that you have 3 limited roles: strategic, support, TA, and monitoring of IDA. But I'm wondering how you see your role during this period of time. And when I ask you that, I want to see if you could give it in like terms where somebody in the public who doesn't know all of our education lingo can understand. Having worked at OSSI before and knowing all the different acronyms, how would you explain it in a non-acronym way?
Thank you so much for your question. I always appreciate a pushback on acronym soup, so thank you. So you hit on a couple of the areas where we provide important oversight, monitoring, technical assistance. There are some consistent ways we monitor with this relationship and some new ways. So we monitor the educational programming for students with disabilities in DOC 4 times a year, including 2 on-site visits and 2 student file reviews. On-site visits include students, school, staff, and DOC interviews. OSSI also visits the DC Jail Education Unit and all units where students receive education routinely out of formal monitoring visits. We also have a memorandum of understanding, or of agreement, excuse me, between us and DOC, where we are providing technical assistance and ongoing support as they navigate this transition. So both on our large scale monitoring, as well as our individual support and technical assistance through the special agreement as a state public agency.
Got it. Got it. And as you look at these two, the piece of legislations before us, is there any way to close this gap that I was just talking to Attorney Winston about, where I know it's not required. So taking requirement out, if it's not required, is there a way for us to figure out what can we do here to close this very real gap? I'm just interested in your opinion as an educational policy person.
Appreciate that. Thank you for your question. So I want to start with ensuring every individual between the ages of 18 and 22 who's in the custody of DOC receives the special education services they're entitled under IDA is a critical priority. What you're raising is a potential gap, and we can respond to that as well. One of the things I have raised already in testimony is the belief that the child find terminology in here is much more expansive than we believe is necessary or required to address the issue that you're raising, right? Gotcha. It is a system of activities designed for a traditional LEA setting, which includes the identification, location, and evaluation. So we believe that is much more expansive. However, if to the extent policymakers want to consider expanding the scope of the framework to include some type of evaluation framework, we recommend that there's a provision of time to the Department of Correction and its educational partners to build out the current framework and consider how best to design an evaluation system in a jail setting with ensuring adherence to student privacy laws, as well as providing OSSI some time to consider how to measure effectiveness of such a system in a setting not otherwise included in a federal law. So it needs a little bit of time, and we would encourage not being as expansive in the requirements in child fine.
Got it. Okay. Awesome. Thank you. Thank you all. My other questions were asked and answered by my colleague, Councilmember Parker, which happens often. It's a good thing when you and your colleagues have the same questions, because it means more than one person is vigilant and paying attention to this really important issue. So thank you for this panel of witnesses, and Chairman, I will yield the rest of my remaining time back to you, Chair.
Thank you, Councilmember. Let me check. I don't have any other questions. Hold on just a second. I don't have any other questions for you all. I want to thank you for your testimony. And so I'm going to close out this hearing. This has been a joint hearing of the Committee of the Whole and the Committee on the Judiciary and Public Safety on 2 bills dealing with special education for young adults in the custody of the Department of Corrections. As I indicated at the beginning, the record in this matter will be open for 2 weeks. So those who promised that they would provide statements or follow-up have until 5 p.m. on Tuesday, January 30th, and anyone else who wants to comment the same deadline if you want it included in the record. The time is 1:09 p.m. and this hearing is adjourned.